In 1990, the Commonwealth Government changed the regulation of pharmacies to make it more difficult for a pharmacy to be approved. The idea was to make sure that only top quality pharmacies could operate. When laws change like this, there is usually a transition scheme so that people who might be halfway through setting up a pharmacy under the old regulations don't suddenly get thrown into disarray. The transition scheme for these changes said that the old rules would apply if the pharmacist entered into a financial commitment prior to 9 August 1990 in the expectation that an approval would be granted in respect of those premises. Gary Smoker, odd name for a pharmacist, planned to open a pharmacy in premises owned by Cenrin. The lease had been finalised but not executed before 9 August 1990. Mr. Smoker had paid his own and Cenrin's legal costs for the preparation of the lease. He had also paid thousands of dollars for technical drawings of the fit-out of the new pharmacy. The approval authority, however, said that to qualify under the transitional arrangements, a financial commitment had to be one which is shown to be ongoing and binding, the revocation of which would involve the applicant pharmacist incurring a substantial financial penalty. They said the lease didn't count because Mr. Smoker could just withdraw. They didn't consider the fit-out costs at all. Justice Foster agreed that the authority had no right to just add extra criteria about the meaning of a financial commitment. He found that a financial commitment had clearly been made. Now, in this case, there was no real dispute about the facts. Both sides agreed on what had happened with the lease and the fit-out. The only dispute was whether this was a financial commitment. There was no point sending the decision back to the authority. The outcome was obvious. His Honour said, "I am of the opinion that the applicant was clearly entitled to a decision in his favour on the material before the authority and that this is not an appropriate case for sending the matter back to the decision maker to be reviewed." He made a declaration that the pharmacy should be approved. From this case, we learn that if there is no dispute of fact, a court can just remake a decision instead of remitting it to the original decision maker.